Hey guys, welcome back. Today we're going over part 3 of the Robert Devine Decertification hearing. And if you're watching this, you probably already know the ins and outs of this case, so I'm not going to rehash everything. And if you are new, you should definitely go and find some other videos on my channel because I talk about this in depth. This is related to the Sandra Birchmore case. I have an entire breakdown essentially of that case, and I've been following the hearing of Robert Devine's decertification. Robert Devine, he's a former deputy chief at the Stoughton Police Department, and he has been accused of having sex with Sandra Birchmore while on duty. But there are also accusations related to a relationship with Sandra Birchmore or some interactions that were inappropriate, especially when she was a minor and in the Stoughton Explorers Program. So again, you should go check that out on my channel, but we are going to dive into this, honestly, on the more quicker side. Now, before we get started though, I do want to say I have been calling Robert Devine and his attorney the defense. And I said in my first video that they are actually the respondent, but I'm going to call them the defense just for the sake of clarity for you guys. I'm going to go back on that. I'm calling them the respondent because that is the correct term, and I don't want to call them an incorrect term. And if you are in part 3 at this point, you know exactly who I'm talking about. You've already gotten used to the situation, so I don't see a point in continuing to call them defendant. They're the respondent. So when I say the respondent, I'm talking about Robert Devine and his attorney. I also want to just mention a big thank you to my members of this channel. You guys make this job a lot easier for me, right? Because the financial strain of doing all of this, it can definitely get to me, and I put a lot of work into this. So for those who are members, I want to thank you guys. Your support truly means the world to me, and it helps me continue doing what I'm doing. I also want to say thank you to anyone and everyone who watches my videos, comments on my videos, talks to me in any degree, goes onto any of my other pages, because again, your support means the world to me. So thank you very much. And if you're interested in being a member, I would totally appreciate it. I do some deep dives on there, or I plan on doing some deep dives on there. I give you guys a little background on, behind the scenes, what I'm doing before it comes out. Sometimes I do a couple little teasers, stuff like that. I want to do polls, all that. I have a very big plan on expanding a community for everyone because I like communicating with you guys. And sometimes I feel like YouTube's not the best format for communicating and the kind of one-on-one interactions that I want. But I do think that the membership option does allow for that. Without further ado, I want to get into it because I'm sure you guys do too. So let's get started. Oh, and real quick, this is a shorter hearing or shorter portion of the hearing. It's a lot of procedural conversation. There are some, again, there's some juicy bits that I think we need to take note of, especially related to who Rober Kuhn is and when he passed the bar and when he went to law school. Because if you were following part 2 and you looked at the recap, that's a big question for us. And that was a big question for these attorneys. Who is he? Could he be the Rob in these alleged text messages or online messages that the division is saying is Robert Devine? But maybe it could be Rober Kuhn. Well, let's break that down and look into it. They talk about it in this part of the hearing. Let's get started.
Sorry. I'll just start over. Good morning, everyone. Today is Friday, June 6, 2025. The time is 10:37 a.m. and this proceeding is hereby called to order. This is the second day of the adjudicatory hearing before the Massachusetts Peace Officer Standards and Training Commission in the matter of Robert Devine. This hearing is closed to the public pursuant to an order issued by the hearing officer on May 30th, 2025. Reconvening in person and only necessary commission staff are permitted to observe the hearing. This hearing is being audio and video recorded, and the party should speak directly into the microphone to ensure the audio in the recording is clear. The commission is represented by Attorney Sean Martinez, and the respondent is represented by Attorney Robert Stowe. My name is Elizabeth Smith, and I'm the hearings administrator for the commission. The Honorable Kenneth J. Fishman will serve as the hearing officer for this proceeding. And before we begin, the parties are reminded to use initials when referring to any alleged victims or minors, and to use a page's specific dates number when referring to any exhibit. And this matters now before Judge Fishman.
Thank you. And for the record, counsel, state their appearances, please.
Good morning. Sean Martinez for the Division of Police Standards.
Morning.
Robert Silva, respondent. Robert Devine.
Morning.
Morning.
So before we begin with evidence today, and Mr. Stowe mentioned on the way in that one of his 2 witnesses is on the way, delayed some, and the other one, I'm not sure about.
Correct. I understand from my client that he's had some in the past of problems with some heart issues, a stent and things like that. So
He's had some what?
Heart problems. He had a stent put in.
Oh.
And we don't. He hasn't reached out to me. My subpoenas have my phone number on the bottom of them. So
which one is that? Which person is that?
So Haley Hogan is on her way.
All right. Well, let's see what happens with that. I do want to start before evidence anyway, just to put on the record that a Boston Globe article was directed to my attention yesterday. And in that article by Laura Grimaldi, she indicated that she had interviewed Mr. Devine, who told her, quote, "I asked for this hearing, I wanted it public, and it's not." So I raise this simply because I want to make sure that the record reflects, as far as I can recall, that neither Mr. Devine or his counsel, Mr. Stowe, throughout these proceedings has ever requested that this hearing be open to the public or objected to the orders to close it. Rather, 2 protective orders were submitted to me for my approval, which were prepared by the parties and agreed to by the parties, both requesting confidentiality. And beyond that, as we were approaching the hearing, I instructed counsel to confer, which they did, which was reported to me that they did, and discuss whether, I asked you to discuss whether confidential matters could be segregated from non-confidential matters at the hearing so that the public could be present at the hearing during the presentation of non-confidential material. I was told that both parties agreed, that they advised me that so many words that they didn't think that would be feasible because of the nature of the evidence. So I'm asking you, first of all, does that accurately reflect the record as far as the party's concerned? I'll start with Mr. Stowe.
Yes, Your Honor.
Okay. Mr. Martinez?
Yes, Your Honor.
And have the parties either changed their view about the need for confidentiality in this case?
I believe my client would like it to be an open forum, but that's his position, and
It's hard for me to know it unless you.
Unless I say it, yes. No, he's expressed to me that he wishes it would be open.
Oh, I don't want to get into. Okay, that's fine that you're telling me that, but I'm just hearing this for the first time now.
I understand.
Is this something that you, at any time, felt you didn't have the opportunity to present to me in the past?
No, I just, it was not presented in the past. And also throughout this hearings, as you know, and any meetings we've had, Mr. Devine's been with me.
On behalf of Mr. Devine, do you believe that there are any circumstances that have changed since the parties presented protective orders to me and discussed the possibility of segregating the material here that would sort of alleviate the need for confidentiality?
I don't think so, Your Honor. My position as counsel, as I've instructed my client, is that this should be confidential. So this is, I've had this discussion.
Okay.
And I guess my position as counsel that this should be a closed hearing.
And Mr. Martinez, has your view changed at all?
It has not, Your Honor.
Okay.
So that is what I like to call a professional judicial smackdown, because, oh man, that is such a mess. I know this is very nerdy of me, but this is so dramatic to me. I'm like, holy cow, because Devine's attorney right now is like, bro, really? Really? You really had to go and do that, right? And he has to, in front of this judge, be like, well, that's my client's position. I disagree. We had a conversation about it. We discussed it. We don't want this to be public, or at least I don't want our position from a legal perspective is that it is going to remain confidential. Yet Devine is going out there behind his attorney's back, going to the public, trying to do some, I don't know, on his own PR here, saying, I want it to be public. Of course I want it to be public. I want it to be transparent. I'm not guilty. I haven't done anything wrong. I don't deserve to be decertified. I didn't have sex with Sandra Birchmore while on duty. I want it to be public. It wasn't me that wanted it private. Buddy, the judge just said that there were 2 protective orders that both parties signed off on, and that your lawyer wants it to be confidential, that there's no way to segregate the confidential material from the stuff that would be appropriate for the public to see. It is not possible. So your little PR stunt probably just really pissed off your lawyer because it makes him look bad in front of the judge, and honestly pissed off the judge. But the judge is so professional in this situation. The way he handles it, he doesn't say what you did is wrong. This is problematic. I'm mad at you. You shouldn't have done this, whatever. He just goes, did you guys, has something changed here? Have you changed your mind? Was there a miscommunication, right? Gives them the opportunity, especially the lawyer, to essentially pivot and respond appropriately. And I personally appreciate this because as a lawyer, you can talk to your client, tell the cows come home about what they should and shouldn't do. But a lot of the times the clients are going to do whatever they want to do. And then you're out there picking up the problem. You're like disaster control, right? You're trying to figure out. And so essentially Stowe here is on damage control, right? And the judge is probably recognizing from his lawyer days that clients can do this kind of stuff, can just go out and come out of left field and do something. And so he's kind of giving the attorney the opportunity to respond and still keep his dignity and honor, right? And also make sure that Devine, it doesn't look necessarily like him and Devine are fighting, right? So he was like, Devine might believe that, but I, as counsel, recommended no. We discussed it's a no, whatever. So I just think that that's fascinating. I do find it really interesting that the division's attorney really paused when he was asked if his opinion changed and then says no. I'm like, okay, what were you thinking about? Maybe he was like spacing out. It looked like he was reading something. Anyway, I find that so fascinating. Like I said, that's a judicial smackdown in the most professional way. So applaud to the judge on this one. But I don't know. I like professional smackdowns because they're a lot harder than non-professional smackdowns. It's easy to insult someone. It's easy to just call someone out. It's harder to do it in a way that is coy and more nuanced and skirts that line. You know what I mean? Anyways, okay. End nerdy rant.
I don't really care what the media says, so I'm not asking it for them. What I do care about is transparency. I do care about the public's right to know. The point, particularly the nature of the kind of proceedings that we're involved with in the post-commission as a general matter. I was persuaded that this is one of those rare occasions where closure and the presence of protective orders were necessary because of the sensitivity of the nature of the evidence that was being presented, particularly even having in mind that it appears that the media has been pretty well informed, for instance, about the nature of the alleged victim, about much of the evidence that's there. I don't know.
You want to come say hi to everyone? Well, I'm filming. You're on right now. It's okay. It's not live. Just come say hi. Want to say hi to my fiance? This is Nick. Just say hi.
Who am I saying this?
My YouTube. Bend down so they can see you. Do you want to? Hi.
Hello in there.
Okay.
Hello, tiny people.
Oh well, that's the hearing.
I know.
Okay. Okay. Well, I'll talk to you later. Okay. See ya. Bye. Don't shut it all the way. Yeah. His Jad likes to come in. Okay. Back to the hearing. Sorry for that interruption. That's my fiance, Nick.
How much they've actually seen, but I've certainly seen a variety of articles out there that seems to discuss some of the details that I've been hearing about through the discovery process and through the evidence as it's been presented at this hearing. So I did struggle for a while with the notion of if it's already out there, what are we protecting in terms of confidentiality? And I don't have any doubt that you've thought about that too.
We all have. We're all wondering.
But there were other factors like the presence of a criminal case in which there was a protective order for probably much of the very same material we're dealing with here. And as far as I know.
What's interesting is I've read the memo for detention for Matthew Farwell that the prosecutors wrote up. And that is so in depth as to a lot of the evidence they have against him. It talks about text messages. It talks about his alleged violent fantasies, his alleged violent sexual fantasies. You know what I'm saying? And so I'm like, okay, like this is already public. Like you can read the memo requesting Matthew Farwell's detention online. And again, I've thought about reading it to you guys. Might make that a lie. Let me know if you're interested in that. So it's like, okay, what else do we not know that needs to be confidential? And of course, we don't know what we don't know. So we don't know. But it's like, okay, a lot of it is public. Like it is a bit annoying that so much of this is redacted to such a degree because it leaves us really in the dark. But hey, it'll hopefully come out in the trial or maybe trials. We'll see who else might get indicted.
I've been heard differently. That's still in place in connection with the criminal case. On the other hand, we have the estate of SB that's involved in what appears to be, I wouldn't say open, but it's certainly a civil case that's on the docket in the Superior Court, which identifies SB's full name. But there is a protective order in that civil case as well, isn't there?
There is, and there was a hearing on it. The question was whether or not the town of Stoughton had to disclose information. And there was a full hearing on it, weighing the balance of the sensitivity of the information with the public's need to know. And that was in the civil case, that was in the post case.
Right. So we sort of all came to the same conclusion.
Correct.
Yeah.
The judge concluded the same as you did.
Okay.
So we all did. It makes sense for the integrity of both that case and this case.
Yeah, it surprised me.
That's interesting. I'm just wondering if the lawyer here, again with the damage control, is trying to come back and kind of simultaneously speak to his own client. You know, kind of inadvertently, he's speaking to the judge, but really he's speaking to the client, where essentially he's like, yeah, in Sandra Birchmore's estate, a civil case, the judge also agreed to a protective order. And Stowe's essentially saying, yeah, I agree with that. Rightfully so. There should be a protective order similar in this hearing, whatever. And Devine's just sitting there next to him like, maybe I shouldn't have talked to the media. At least I think that's what the judge and Stowe are both hoping in that situation. But you don't really see him sinking in his seat, but I think he is mentally.
Because as I consider the factors, that the estate, at least now, is taking somewhat of a contrary position. You know, oddly enough, they asked to appear in this proceeding. They didn't say open it up to everybody. They wanted to be present. I don't know what their position would be about generally open to the public hearing or not. But given the nature, particularly of what I was focused on yesterday as a result of presentation of evidence, beyond the identity of SB, there's her communications. And it's to somebody who's from somebody involved with somebody who's no longer alive. And it's the nature of those communications and the impact it could have on her reputation and other aspects of her life, that the estate would be open to or agree with the opening of these proceedings. During the civil case, when there was a hearing, Mr. Stowe, did the state take a contrary position? Did they want it open?
I remember. As far as the disclosure of the evidence, I don't recall. I know there was I think we had 2 hearings on it. Because we had the Attorney General's office information as well that they were trying to secure. And this was actually the town of Stoughton. I don't know if it's the town of Stoughton that filed for the protective order. I believe it was.
But you don't recall what position the state took?
I don't.
All right. Is there anything else so that our record can be as complete as possible that anybody wants to add at this point?
Just as far as the civil case, the state is now requesting that the civil case be stayed in Norfolk Superior Court. So,
because of the criminal case?
I haven't seen the motion. I asked to be served 9A of the motion. Mm-hmm. My concern was not, well, if the case gets stayed, what about the interest? The interest should be stayed. And I think that's going to be my limited objection to saying it is the interest should be stayed as well.
Yeah, but you don't know the grounds for the stay at this point.
I haven't seen the motion.
Mr. Martinez, you want to add anything?
No, Your Honor, I don't.
All right. So you're comfortable with continuing to proceed in the manner in which we began these hearings?
I am. I would certainly hesitate, in particular at this point, to open up the hearing if the division's witnesses were behind a closed hearing, and then to have Mr. Klein testify in public. I think that would be an issue.
I actually thought about that as well as I was considering these developments. So,
Wait, I need to rewind that. Did I catch that correctly?
That's going to be my limited objection to saying it is the inference should be stated as well.
Yeah, but you don't know the grounds for the stay at this
I
point.
haven't seen the motion.
Mr. Martinez, you want to add anything?
No, Your Honor, I don't.
So you're comfortable with continuing to proceed in the manner in which we began these hearings?
I am. I would certainly hesitate, in particular at this point, to open up the hearing if the division's witnesses were behind a closed hearing, and then to have Mr. Devine testify in public. I think that would be an issue.
Dang, he didn't say what I thought he did. I got excited for no reason. I'm sorry, guys. I've got you too excited. I thought he was saying I'm okay with the division's witnesses like being behind closed doors, but maybe Devine should be public. In my opinion, I don't know if Devine would want his testimony public. Like, I don't know. As the division's attorney, I'd have a little fun destroying him in the cross publicly, but that's not what he said. He essentially saying I would have an issue if the I would have an issue if the division's witnesses were behind closed doors, but Devine's was public. He said he would take issue with that, which, okay, I could see that. But I was kind of hoping for the drama of it. He was kind of jabbing Devine a little bit, but he wasn't. He's too professional to do that.
I've actually thought about that as well as I was considering these developments. So, and we can't turn the clock back. So that's, I haven't figured out how to do that yet.
Yeah, I kind of wanted the division to be a little, catch me outside, right? Like, okay, you want it public? Let's make your testimony public. Let's make your cross public. Let's have fun, Devine. But he did not do that. I'm a little too petty, I guess. I don't know. Or maybe I just like the drama a little bit too much.
The one, just given it, in particular, Mr. Devine's Mr. Stowe's representation that Mr. Devine had never before made his wish known about being public, I would ask permission to cross-examine him on the statement he made to the Globe as well.
Okay, I want him to cross Devine on the statement he made to the public. Given the idea that Devine apparently never brought it up to his attorney that he wanted to go public. So, but then he goes to the media and wants it to be public. I want to cross-examine him on that. I want to ask him about that. Okay, I see it.
I mean, when Mr. Devine takes the stand.
Yes.
All right. Well, let me deal with that when it comes.
Yes.
All right. But thanks for forewarning me, and Mr. Stowe as well. All right. Is there anything else you want?
Oh, man, I wish I could hear that conversation between Stowe and Devine after this. Stowe's like, boy, bro, brother, why?
To talk about briefs while we're waiting for the witness to come?
So I do have information because the bar status of Rober Kuhn was an issue yesterday. I do have a similar proposed exhibit, or ask that the clerk make a judicial notice of Rober Kuhn's bar status. May I approach?
Yes.
You're right. I mean, we didn't say bar status. We said he was in law school.
I'll let you talk about it. Let me see what we're talking about. You know what?
No. Law school and bar status were both on the table. They were both talked about. It wasn't just law school. It was also the bar status. I remember. I kept track. I took notes.
This is, we have a let me ask you, we can make one for identification or a fee for identification.
Yes.
Thank you. And does this come from the bar website?
Yes, it does. I took a screenshot this morning when I searched for Rober Kuhn. I also double checked the commission's databases, and the middle name of the Stoughton police officer is the same as the admitted attorney.
Robert Jerome Kuhn.
Yes.
All right. So what's your position about this document?
Your Honor, we had said the question before the witness was about Rober Kuhn's being in law school. I can believe his testimony was nobody graduated. The name was Robert. Nobody's in law school. He brought up the word law school. That's when he brought up the name Rober Kuhn, and he says no, he wasn't. A word to that effect. And he said, well, yeah, he was. I think he said, well, maybe he was. And so it wasn't a representation at graduate, it was a representation at law school. And if you look at this, I mean, sworn in November 15, 2022, I suspect that he was in law school in 2021.
Yeah, unless he took time off between law school and admission, but who knows? I don't know. We really need to go down that. What do you say about that? I know the question originally was about law school. My memory is it got a little blurred by his answer. But I think that Mr. Holmes, not being completely responsive to your question, what Mr. Stowe was that he did say that another officer, this fellow Rober Kuhn, had become a lawyer around that time, so which implies potentially that it's a member of the bar. Again, I know you were focused on the question of whether anybody in law school. I do recall your question, but so what do you say about that?
My recollection of the testimony is the same as yours, Your Honor. And also just the fact that the evidence in the case, the statement that we're all circling around is the text message that's on the admission date of Robert Devine. The fact that there's talk of another Robert at the Stoughton Police Department either being in law school or potentially being an attorney at the time is now relevant to this hearing, and this shows that he has a different admission date than Mr. Devine.
Okay, so that's my recollection too. They did talk about the bar admissions as well, or the bar admission as well. They talked about when he became a lawyer, right? That means you passed the bar. You have to get sworn in. And so they say that Robert Jerome Kuhn, his bar admission date was November 2022. Sandra Birchmore died in 2021. So if a conversation between Sandra Birchmore and a Rob was about a bar admission date, unless it was like my future bar admission date is going to be November 2022, but it's like, okay, that's if you pass the bar. That's very forward looking. And that doesn't seem to be the conversation here. It was about a current or past bar admission date. Guess what? Robert Jerome Kuhn had not passed the bar yet during this conversation because this was before Sandra Birchmore died in 2021 and before Robert Kuhn even got sworn in on November of 2022. So like the division's attorney says, Robert Devine's bar admission date is different than Robert Kuhn's. And that is very important to this text message thread, apparently, that we do not get to see.
If I may, Judge, the actual quote is not. I think the actual quote is.
What is the actual quote? Please tell us.
The text messages, and then the immediate next text messages.
I just want to be clear.
Okay. But do you disagree with that?
No, I agree with that.
Okay. All right. So I think what we're talking about really goes to the weight of the evidence at this point. I think it doesn't change its admissibility. And certainly something I'll have to put in context when I decide if its value in terms of deciding this case. So I'm going to admit what we marked as Exhibit B as the next numbered exhibit.
Yeah, so without us having the text messages, we can't come to a definitive conclusion as to whether the fact that Robert Kuhn's bar admission date was November 2022, like whether that's actually important, imperative, integral to this situation, to these text messages. But I do think it is important for us to note that it is different than Robert Devine's. It is after Sandra Birchmore died. And so kind of seems like the conversation may not be related to Robert Kuhn, but rather Robert Devine, as alleged by the division.
If I may, I'd just like to point out the fact that I've raised over and over again.
The what?
I'd just like to point out the fact I've raised over and over again that Mr. Devine cannot cross-examine SB because she's not here. So we've got that ongoing problem with that. You know, his due process rights. And of course, we've challenged and we're going to continue to challenge the authenticity.
And so the record is clear. I certainly understand that. And as far as I'm concerned, your rights are preserved. Otherwise, with regard to virtually every single question that involves a communication involving SB, you'd have to make this objection again. But you have a continuing objection.
Thank you.
So that's interesting. Stowe, the respondent's attorney, the respondent Stowe, he's essentially pointing out that, he cannot cross Sandra Birchmore because she's dead. Okay, yeah. That's a problem for their case. That is what he's saying. That being said, he's also taking advantage of the fact that Sandra Birchmore is not present by disparaging her entire reputation, essentially, calling her a liar, saying that she's working with William Farwell to perpetuate a big lie about Devine, yada, yada. So he's using Sandra Birchmore's death to protect his client while simultaneously using her death as a tool to avoid this whole decertification, to contest the decertification and make sure that Robert Devine is not decertified. So, I mean, that's a tactic. Okay, I'm not even going to, I'm not going to make any moral points about that. It is unfortunate that when somebody dies that this can happen. But at the end of the day, Robert Devine hired him and he is a lawyer and he's going to protect his client in the best way possible.
So you said it was you. I don't know if you wanted to do numbers or letters because we have been doing numbers.
For ID, I'm talking about
Okay.
versus A and B or ID.
Apologies. Yeah, that would be exhibit 11.
I think we're at exhibit 11.
That's what you just
Okay.
said.
Thank you.
It's great when we all agree. Let's talk a little bit about schedule since we don't have the witness yet.
Sorry, this is.
Witness is here? No,
Yes,
let's get.
but if you'd like to.
No, we can do that later. I was just sort of filling the blank.
All right.
Your Honor, if I may inquire, when you left yesterday, you, I believe, instructed the division to find out about the transcript.
Yes, you were going to try to communicate with the chief. Were you able to do that?
Yes, I was.
Anything
So
we should know.
Chief McNamara, I spoke with her just this morning at approximately 10:15. She was able to locate all the written transcripts, and she's in the process of locating the audio transcripts, as well as Mr. Devine.
Audio recording.
The audio recording, yes, of the interviews, as well as she's working to locate the Weingarten and Garrity and interview warnings for Mr. Devine. She read the first page of the transcript to me, and there is definitely an acknowledgement of.
When Mr. Devine was
That's
interviewed.
correct. Yeah.
So there's a transcript of his interview as well?
That's correct.
Your Honor, given
Never
the,
seen that?
I've never seen it in any form. And I hesitate to have my client take the stand without.
I just want to clarify that because it's very muffled. He essentially said, given the fact that my client has never seen the transcript, and then he's going on to make an argument as to what he believes they should do in the future moving forward because Devine has not seen his own transcript of his own interview during the 2021 investigation.
I'm first being given the opportunity to review a transcript of his statement to the police department that has never been produced.
And I don't blame you. Why? So we heard from Chief Holmes yesterday that from his perspective, all of that had been turned over to you folks.
Yes.
And I think he said, and I credit that you've checked and double checked.
Yes, I also went back to my office yesterday and checked, and the assigned investigator also checked. And
none of this material was there. I mean, these transcripts or the audio recordings or the notice.
So Stowe said, the respondent said, I want my client to review his transcript before he testifies. Yeah, for sure. That makes sense. Because the division is going to be reviewing it at this point. They are also talking about how Holmes essentially testified that he gave the transcripts to the division. And the division saying, I've double checked at this point. We never got the transcripts. We don't have them, all of that. So this just seems to be a miscommunication and a record keeping problem. My guess, based on what I've heard, is that Holmes gave everything that the 2021 investigation encompassed, that folder, to the division, and then just assumed the transcripts were in there at this point in time, because we are like years later now, right? But he did say that the investigation folder itself, the write-up, the report, did not include the transcripts. So my guess is Holmes is like, I thought the folder had the transcripts. I gave it to the division. In reality, the transcripts were not contained in the folder. That's bad record keeping, in my opinion. It should have been kept in the folder. Does it need to be part of the executive summary report, like the executive report? Not necessarily. That would be a little redundant. That'd be a little crazy, but it should be in the file, obviously. Thankfully, it seems like McNamara is getting access to, or already has access to, the written transcript. She's trying to get the audio transcript right now. So they have it in their files, thankfully, and that should be turned over, and that won't be a problem. But it just seems to be kind of a miscommunication here.
So it's the pursuant to the IA procedure, none of that.
That's correct. The hard drive that has been the primary discovery device in this case is what we received from the Stoughton Police Department, and I made an exact copy and turned it over to respondent. That was the representation of the case file. I had turned over the IA report and the exhibits, which are Exhibit 1. We had received those separately from the electronic exhibits. That's why they're separate as Exhibit 1 and Exhibit 2. And I've returned them, or I've turned them over to the respondent in the same form that we received them.
And you both had a chance to obviously thoroughly review those two bodies of evidence. So, and you both concur that the material we're talking about, the transcript recordings themselves, are not contained in there, nor are the warnings that we were talking about yesterday.
Yes.
So what do you say about?
Do you hear that high ringing sound that kind of going through the speaker, through the mic? This is a totally random observation, but I just saw the judge essentially like push on his ear, and I'm wondering if he has a hearing aid. I don't know. Have you ever? My grandpa always had a hearing aid. It would ring. I'm wondering if it's ringing and being caught in the mic. That's a totally random observation, but I'm just like, what?
About Mr. Devine having an opportunity to review his interview before he takes a stand in this matter.
I have absolutely no issue with that.
We all agree on that as well. So let's see. So let me ask you this: how is she going to provide that material to you?
So I spoke with her this morning and suggested a few things. I think that she's going to think them over today, and I told her that I'd call her either at lunch or at the end of the day to arrange for copying. I met with her last week at the Stoughton Police Department. I don't mind going to pick them up and make copies or whatever I need to do as well.
Which suggests, of course, just to state the obvious, that Mr. Devine and his counsel won't have this material in time for him to testify today.
Correct. I think the expectation, regardless, was that Mr. Stowe had at least a few hours of crossing Deputy Chief Holmes, and he's not expected to get here until 2 p.m. So I think that was hopeful. A hopeful thought that he would begin to testify today, but I think that's fair to say.
So putting on, although it was many years ago when I was sitting up behind those desks as a lawyer, that's when Ben Franklin and I used to be. If I were sitting in his shoes, I might be saying right now, well, wait a second, I've got Holmes on the stand who has relied on material which he said existed, and that's not inconsistent with what we're now learning, but is somewhat inconsistent is his assurances that everything was provided to post. But putting that aside, this is material he reviewed when he wrote his report. And the reports are kind of, I'm hearing just sort of a summary of what these interviews were saying, or identifying the stuff that he was most interested in and thought was important. So as I was saying, if I were in Mr. Stowe's seat, I might be saying to myself, Well, how can I complete my cross without having a chance to review those transcripts and recordings as well? Is that something Mr. Stowe might say?
That's something Mr. Stowe is saying. I can't. I just went through all the witness statements with him in his report, and now we're going to get them into what they really say.
I get it. And I'm sure you don't think differently.
I would consent to that. And after the testimony yesterday morning, I would not have been surprised if after we received the transcripts that those witnesses would be recalled. And that's something that the division would not oppose either.
Yeah, so the judge just kind of threw Stowe a bone here. I mean, I don't know if Stowe really needed a bone to be thrown because maybe he would have said this on his own. But the judge was just like, now that you guys are going to get the transcript and you want Holmes to come here for a cross, and Holmes relied on those transcripts in his summary, in his IA report, you might want to read those transcripts before continuing that cross. And Stowe's like, yeah, that is what I'm saying, right? So again, further proof, the judge wants a fair hearing right now. The judge wants this to be fair. It's very obvious he wants it to be fair, and I appreciate that.
But however, if it needs to be done and we need to put off Chief Holmes's cross for another day or even continuing so that we're all on the same page, I don't think that we would object either.
It makes sense.
That's me too. I don't, we worked very hard. Everybody did about getting ready for this. I appreciate that. It's a part of the effort that we're making it post to do these things in a timely manner and in the interest of both the respondent and the division. And, we do the best we can, but sometimes circumstances arise which change the impact of proceedings. So I can't imagine that we wouldn't give you a chance to do that. I think we should, rather than have to repeat stuff, we should get word to Chief Holmes, who will be advising him of when he has to come back and reminding him of his obligations under the protective orders. Is that agreeable to everybody?
Yeah. Yes.
Yes.
And when we get done, do you have a problem with now that we have at least one of these witnesses here? It's a her, right?
Correct. Yes.
Her on.
Yes.
Are you okay with putting her on out of certain here?
No, I'd like to preserve and take her.
Was she recorded? No, she wasn't. No.
She has an affidavit, which is page 763.
Okay. So but there's no recording of her, of an interview of her?
No.
Okay.
I would ask that given the witnesses here that, actually, I'll defer to Mr. Stowe. However, if the witness does not return, I would also put that on the other party as well to ensure her.
That's right. Well, let's do this. You're requesting that you don't put on any evidence until the division's case is fully presented.
Correct. And now we've got these, as we've said, we've got all these transcripts to go through. I would have expected that to be done with Deputy Chief Holmes today, but now it's going to go through a volume.
Well, I would suggest this. Well, and before you take a position on what Mr. Martinez just said, why don't I bring a witness in? Explain the witness that circumstances have require that other evidence be presented before she gets a chance to testify. Tell her that, is she literally under subpoena?
Yes.
Okay. That she's under subpoena, that she's going to be advised at a new date. She's going to be required to appear on that date. Ask her if she's willing to do so. And if she resists at all, to explain the consequences of violating the subpoena.
Makes sense.
Everybody all right with that?
That's fine. Yes.
So why don't we go ahead and bring her in? Thank you.
Skip.
AJ. As a turn matter, so for instance, that new day proceedings
We'll be out of state in 2
scheduled the new
24.
I subpoenaed them both for 10.
So I just skipped all that because they did exactly what the judge said he was going to do. They brought the witness in. They were like, hey, given the circumstances, you're not going to testify today. She was like, okay, well, I have some conflicts. They said, okay, blah, blah, blah. Not necessary to watch that.
O'clock this morning. I actually subpoenaed them for the other building. And then we got the notice of change. I sent her the letter with your instruction about the weapons policy. So they would have received that as well.
You haven't heard from him?
I haven't heard from him.
Have you made any effort to contact him?
I don't know. We don't have a number. Devine has tried.
So you have a number to call him at? And
Do you have a number?
It goes straight to voicemail right now. So I don't know what the issue is. Like I said, he has.
so that's good to know, because having told me that, I'm going to ask you to contact him in writing and contact him by leaving a voicemail for him, so he knows that he was required to be here, but as things turned out, his appearance has been continued to whatever date we figure finally schedule. Make sure you.
This is regarding the second witness that was supposed to show up today. I guess he's not, or she is not, he or she is not responding to calls, can't get hold of them, blah, 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 going to voicemail. So the judge is just like, hey, you need to contact them and say that their testimony is going to be continued into the future, not happening today.
Get it to him in writing as well. Remind him that the hearing officer has stated that he's still under subpoena. And again, all right. Anything else we should be thinking about then? You'll I'd be interested even if for some reason that I can't anticipate, the material you received from the Stoughton Police Department that we're talking about today doesn't get introduced into evidence in this case, because I have a parallel concern about the failure to provide that material to the position. I want to make sure that we get copies of it as well.
Yes,
But whether it's admitted or not is another question.
no problem.
One issue with scheduling, Your Honor, is that if I get this information and then it leads to me having to do some follow-up discovery or subpoenaing in witnesses that are referenced in those statements. If the statements are starkly different from what any of the information I've seen, I may want to subpoena those witnesses. And I need some lead time to do that. So first, I don't know when I'm going to get them. I presume I'm going to get them. I've been working with Attorney Martinez for a while.
My guess is you're going to get these pretty quickly.
Yes, I would like to give the chief an opportunity to collect everything so that I can make one trip. I'm in the office Monday and Wednesday of next week. I plan to go down on either one of those two dates. And Attorney Stowe is always pretty amenable of coming down to the office. My plan is to, if I get a hard copy of the transcripts, is to scan them and make a digital copy to make it easier for everybody.
It's interesting to watch this because I've noticed Stowe do this multiple times. Essentially, what I said prior, crafting a narrative around Sandra, around this case, around these transcripts. He has used words multiple times that allude to the idea that the transcript is going to be vastly different than what is included in the IA, in the summaries that Holmes wrote. And of course, he is doing that because he is trying to further push this narrative, this idea that Holmes was and is biased, that the 2021 investigation is not a good investigation, that it was tainted, that it is not indicative or it does not reflect Robert Devine at all, that he did not have sex with Sandra Birchmore while on duty, all of that. And so the way he uses his language to talk about these transcripts, right now he's saying, hey, there might be other witnesses I want to subpoena because the transcripts are going to be so different than the summaries that Holmes wrote. I might not even know of the witnesses right now that I would otherwise subpoena because I didn't read the transcripts. And so he's saying, I need a little more time because other people might be involved that I did not know prior. Because again, it was not mentioned in the IA because Holmes is biased and the entire IA report is BS, right? That's kind of like the narrative that he is creating right now, which is very interesting to watch in real time.
So I would very much expect by the end of next week that everybody should have the materials.
Yeah, but there's also the audio recordings, right?
Correct.
Yeah.
That's what she's currently trying to locate.
Oh, right.
Yes.
But I mean, somehow you'd have to get copies of those to.
Correct. Yes, attorney still usually comes into the post office. We've had, the post commission office. The post commission office. He's been probably 8 or 9 times already. So we fairly consistently have met.
You know, it's mostly retired people that go to the post office. All right, that's helpful. Anything else the parties want to bring up while we're here?
I will say in scheduling a hearing or in scheduling the next hearing date, just given that we're not currently aware of the volume, I think it would be, I would like to check with Chief Holmes in scheduling.
Yes.
I think it would be that maybe we could do suggested hearing dates at the end of next week.
That's fine.
Once we have an idea. And then
Well, and I have in mind that it actually may impact both sides, whether you want to get a further information or further investigation. So I want to leave enough time for you to do that.
And the only thing that I could expect will be an issue with collecting the materials is if they're in Chief Holmes's possession. He's currently under cross. I don't mind having a witness present or anything to show that if we're discussing things that it's only the collection of materials, or I don't mind working with the post-commission legal department either to collect those documents if they happen to be in Chief Holmes's possession. I do just want everyone to be aware that it's a possibility that he may have copies and he's currently on the stand. I don't. In other words, I know I'm not supposed to speak to him about the case.
Oh,
because,
I see what you're saying.
Because he's currently.
He may have, even though he's no longer a part of the department, he may have copies.
Yes.
Is there a specific reason you believe that, or just it's a possibility?
So Chief McNamara suggested to me that Chief Holmes was the one who was in charge of the investigation, and he will know where the materials are. I'm not necessarily suggesting that he is in physical possession of them, but he may be the person who knows where they are, and he will have to coordinate with either me or Chief McNamara for those materials.
Are you, whether he has them or he will have access to them as a result of helping to collect them, do you have a position on whether he should? Either one of you have a position on whether he should be able to review any of that material before he gets back to the witness.
Given his testimony where he gave representations to the court that Mr. Devine had said he never had any contact with SP, and in fact the report said something different. I want his memory to be as it is, not refreshed by documents that nobody's seen on either side of the table. So I'd like his memory to be fresh, to just be his memory versus him.
That makes sense that the respondent would want Holmes's memory to be as is rather than allow him to review the transcript, especially if he's in the middle of a cross right now, because since he already knows the respondent's hand, right? To a degree, right? Stowe has already played his hand, already has painted him out to be biased, all of that kind of stuff. Holmes has already said certain things on the stand. Now, if he can go back and review the transcript based on what he knows on Stowe's argument, that might put him in a position where he can change his memory and change his responses to questions. And that's kind of tainting his actual investigation. It's tainting his actual response, his testimony, all of that. So I understand why Stowe is like, I don't want him to review these transcripts, right? And I'm actually glad the division brought this up, that a witness on the case who is in the middle of a cross might end up having access to those transcripts because he apparently is the only one that knows where they are, even though he no longer works at the Stoughton Police Department, which that's a whole side thing that I think very suspicious and weird, but whatever. Again, record keeping issues.
Refreshing it this time. We need to refresh it with the documents. That's fine. That's what we do. But for him to prepare with documents that we haven't seen, I think is prejudicial to us.
Yeah. So refreshing your memory while on the stand is one thing that is appropriate and can be done, and that's what Stowe is saying. But he's saying, I don't think we should let him read the whole transcript prior to the continuation of his cross and have him essentially prep what his responses might be rather than his memory based on his 2021 actions, right?
I think that that's a fair notion. However, my recollection of the testimony is that he was reading off the page and said, clearly, he had no social contact. Just want to make that one distinction. But other than that, I do not. Yes.
My only question is, we have a problem with instructing him not to review this material at this point in time.
I do not, and I'm more than happy to do so.
All right, if you tell us the order of the hearing officer as well, okay?
Yes.
Thank you. Else?
So I have not subpoenaed the Stoughton Police Department for the documents, but I did let Chief McNamara know if by the middle of next week we had not received them, that I would be serving a subpoena. I don't mind issuing that as a party. However, I know that you're going to be away, but if for whatever reason it needs to be signed off on, or you believe it needs to be signed off on by you, I can also provide a copy for your signature as well.
Yeah, and I'm not out of touch.
Yes.
So,
Okay.
So I'm thinking about that now, about whether under the unusual circumstances that we find ourselves in, whether even if they're willing to voluntarily find and produce this material, that it should be under subpoena anyway, just so they understand their obligation. It's not it's more than a request. Are you right with Devine issuing and having a subpoena done?
I think this is good because we already have evidence of just really bad record keeping. And it's like, okay, let's keep this tight. Let's keep it tidy. Let's make it official. This isn't a request. You're going to be subpoenaed. We need all of that. And then it puts the situation, or it puts the individuals in a situation where it's like, if you don't provide the necessary documents, if you forget to provide some transcripts or something, there is a legitimate situation here, right? You did not follow the directions of the subpoena, rather than just like, oh, we're requesting this, and then later it's like, oopsie daisy, I just forgot, whatever. But there's no official action here because they weren't subpoenaed, right? You want things on the record. You want potential recourse if things go wrong. So again, really happy the judge did this. Let's keep a record keeping tight and tidy. Let's make it good. Let's stop following what these police departments seem to be doing, which is messing up the record keeping, messing up the chain of custody, mess up everything. I'm looking at the Karen Reed trial right now. That's what I'm thinking about.
So why don't you arrange for that? Follow that proceeding.
Just as of now, just so we don't have to go back and forth, are the three things the written transcripts, the audio transcripts, and the interview warning documents that we're looking for?
Yes, that's, I believe, that's what you testified. Yeah, and we're provided. This is more that we haven't got.
So the only other thing that occurred to me, but I think that there were one or two witnesses where rather than a recorded interview, they said there was summaries. He said, see summary below. It turned out that there wasn't one, but then when you went down further, we found the summary. Were there any others that were similarly stated where they said there's a summary, but there was none?
So I think the three, I had jotted them down to do redirect. I think the three that had mentioned came back up later when sort of we scrolled down the document.
All three of them.
Yes, I don't think that, I crossed them off. I don't think that we needed to clean that up any further.
All right, but in answer to your question, if you folks look at this and you say, wait a second, Mr. X's summary wasn't there, even though it said it was in the thing, make sure you include that in the materials that they need to look for and produce.
Okay.
All right. It may be unnecessary, as you suggested.
Okay. That sounds good.
Anything else? All right. Well, we'll be in touch, and certainly about scheduling. I don't need to tell you that we're still bound by the protective orders, the order of closure here. We have a curious media, which is their job. So, but I can't talk substantively about this. All right, be in recess.
The end of part 3. That was a short one. I appreciate a short one. The next 2 are going to be very long. I asked you guys in a post if you want me to do a kind of like a 1-hour deep dive on Robert Devine's testimony and the remainder of Holmes's cross, rather than do this kind of thing where I watch the hearing and talk as it goes, because Robert Devine's is over 3 hours and the remainder of Holmes's is almost 3 hours. So these are going to be insanely long portions of the hearing with very long videos. So I was thinking, what if I distill it into like an hour-long video? I break it down, I give you the highlights. It's like the recap, but on steroids, essentially. I include inserts of the major parts of the hearing, so you're still watching the hearing. I cut out the fluff. Let me know what you think about that. I have you guys voting on a poll right now in a post, but if you have not seen that and instead you watch this, comment and let me know. I'm leaning towards doing the deep dive video, the more official deep dive video, rather than responding to the hearing, just because I don't know if a 4-hour long video is really going to be productive for all of us. I'd rather break it down for you. And then I'll still do the mini recaps as well. Still break it down in those small little 15-minute, 8-minute segments, which is what I'm going to do with this after I finish this video right now. But so that's that. We didn't have any witnesses, mainly just talked about more procedural things. Again, watch the recap if you want me to break it down again and you just want kind of like hard hitters, fast and quick, let you know what happened in this video. But other than that, this video is done. I'm again going to try and sign off and not be awkward, but I literally don't know how to end videos. If you have a recommendation for that, let me know in the comments. How should I end my videos? I just feel super weird. But yeah, until next time, I don't know. Until next time, stay safe and stay curious. See you later.